Hello, there we are. We're online. Hi, everybody. Good afternoon and welcome to LAW2022 Online, Wills and Probate Shape the Debate event with me, Dominic Hendry of Estate Research, as well as being very pleased to be joined today by Professor Leslie King and James Beresford, I should say. Sorry, James, butchering your name there. We are delighted to be joined by James and Leslie today. In this live session today, you'll be able to put your questions to Professor King and to James and interact as the information is delivered. Today's Q&A is due to last 1 hour, and we'll cover some pre-submitted questions that some of you have kindly already put in, as well as live questions that you can add now. To the right-hand side of your screen, you should be able to see a chat function. All questions are submitted, go through to the solicitors group in private, so there's no privacy issues there, and then they are going to pick a selection of those questions to feed through to me, and then I will put those to James and Leslie as we trundle along. Recording of today's live session will be available on the website within the next few days. If you are watching this on record, please just be aware that the chat function is disabled. But if you do have any questions or any further information you would like to ask, please do contact the solicitors group. A little bit about me. Some of you will know from live events. My name's Dom Hendry of Estate Research. I'm the head of private client here. My team specialises on tracing missing heirs and beneficiaries and professionally verifying and reconstituting family trees for private client solicitors. So if you do have any missing beneficiaries, any family trees you would like checking, please do get in contact with the solicitors group and they'll pass that on to myself, or you can email me directly at pc@estateresearch.co.uk. As I said before, delighted to be joined by Professor King and James Beresford. Good morning, good afternoon. I'm going late. Good afternoon to you both. Many of you will know, if you've ever been to a solicitors group event live, you will know Leslie and you will know James, two of the country's best speakers, both of whom I've known for quite a long time at this point. Professor Leslie King, you will all know. I think she needs no introduction, but the solicitors group tell me we should do an introduction anyway. Professor Leslie King is a professional author and lecturer in wills, trusts and probate, a former member of the Law Society's Wills and Equity Committee and Probate and Estates Committee of STEP. And Leslie, I'm told, an honorary member of the Association of Contentious Trusts and Probate Specialists.
Yes.
Away there you go. You learn something new every day. Leslie's also a professional development consultant at the University of Law, and you will all know writes and lectures extensively on private client matters. Also, if you're ever in a technological fix, Leslie is your person. Excellent tech support, as I found out at many live events throughout the country this year. Leslie's LAW2022 online sessions this year have included avoiding and dealing with claims under the PFDA 1975, and where are we now on the trust register? Don't we love talking about the trust register, Leslie? It's been fun for everybody this year. James is a lecturer specialising in wills, drafting and estate administration matters, and helps his clients dealing with their legacy planning, providing a comprehensive and understandable solutions. He's also a wealth preservation specialist focusing on inheritance acts for high-profile individuals, hopefully not higher profile than me and you, James, but there we go, and advising business owners on succession planning. I'm told that, James, I didn't know this about you either, but you've been awarded with 2 Private Client Team of the Year trophies at the Manchester Legal Awards. Is this correct?
It is correct.
Kudos on you. I didn't know this. I'll have to send you late champagne as congratulations. And James actually authored No Will, No Say, which is a simple guide to wills and estate planning, which was published in 2017. James, as I know for many years, has worked with the solicitors group delivering a kind of intro to wills session, which are always absolutely fantastic for beginners, and certainly for someone like me, who's way below the level where I can understand Professor King. But James's sort of lectures have always made it simple for the everyman, which is probably very much myself. I'm told that James's sessions for Law 2022 this year have included the mental capacity and preparation of wills and lasting powers of attorney. Right, I think that's more than enough waffle and introductions from me. So we're going to get straight in to the pre-submitted questions, if that's okay, Leslie, with you and James. Mm-hmm. Excellent. Okay, this is a rather long one, so do bear with me, and I shall do my best to read this out on the piece of paper I'm looking at now. In January 2013, W and H put their home into trust with W and H and their adult children as trustees. The value in January 2013 was £300,000. W and H were given an IIP for the lifetime jointly or to the survivor of them. They completed forms IHT 100. After the IIP's end, the trust fund is held for the surviving children in equal shares absolutely. H died in 2021, and W wants to know when she dies, she can use her RNRB as well as H's transferable RNRB. Would it be better to take the house out of trust and appoint it to W? Are there any CGT implications to doing this, or can PPR be claimed? And then it goes on to say, if the family home continues to remain in the trust, will the trust have to be registered with, once again, our favourite topic, the TRS? So, Leslie, I think I'll direct that to you firstly, and then perhaps James can give his thoughts if he wants to as well.
Well, there's quite a lot of questions in there.
Yes.
So just going through fairly briefly, what you have got is a relevant property trust, because the property went into the trust after the crucial 2006 date. So it's a relevant property trust. When the property comes out, when the surviving wife dies, it's coming out of a relevant property trust. So there will be an exit charge for IHT. Residence nil rate band, completely irrelevant. So if the house comes out of the trust, no residence nil rate band available. But of course, the property isn't in the estate of the wife because she doesn't have a qualifying interest in possession. She just has an interest in the relevant property trust. So if the trustees, I'm not going to say whether it's better or worse if the trustees appoint the house out to the wife, but they could do that. If they did that, it would be an exit from a relevant property trust. But looking at the values, it doesn't look as if there would be an immediate charge to inheritance tax. Looks as if it would be covered probably by the nil rate band, but you'd have to look at the values. Capital gains tax shouldn't be an issue because the main residence exemption will be available. So if you give the house to the wife, it is then in her estate for IHT, but she could leave it to the children and the residence nil rate band would then be available. If the trust is kept going, then yes, it will have to be registered on the trust's register unless it comes within one of the exclusions. And one of the exclusions is it's called the co-ownership exclusion, but it applies where the legal and beneficial interests are the same. So if the wife and the, let's say, two children are the only beneficiaries and they are also the trustees, then you would come within the co-ownership exclusion. But if your trustees and beneficiaries are different, then yes, it has to be registered. I think that's it.
I think you're pretty comprehensive. Anything to add there, James?
I don't think there's anything I could add to that.
No, absolutely. Far too comprehensive, Professor King, far too comprehensive. Okay, we'll move on to question 2. I think I'll address this to you, James, first, but anyone feel free to answer, obviously. Do we need to make 2 separate wills in case assets are both in the UK and abroad, or just one will in the UK is sufficient to cover assets in 2 or more countries? And it goes on to say, if one will is sufficient, how it works for assets abroad.
I think the answer to that question really is, it depends. It depends where the assets are situated. It depends on the type of assets, whether they're movable or immovable. And in most cases, you tend to want to go down the route of having a will in the UK to cover UK assets and a will abroad. But there are cases where the foreign country will accept a UK will with an appropriately drafted clause. But from a practical point of view, I would urge caution here, because you don't know what you don't know. And if you're trying to dispose of foreign assets in a UK will and you are dabbling, that can cause lots of problems. And when you bear in mind that 1 in 4 professionally prepared wills don't reflect the intentions of the testator, you're going to have yourself an issue. Anytime, in my view, anytime you have foreign assets, use a solicitor lawyer qualified in that jurisdiction. Please don't dabble, have a go drafting the clauses yourself. I know there are firms now in the UK who will have dual qualified lawyers. You know, I know of one firm that has German, Italian, Spanish, French dual qualified lawyers on the books who are able to advise. So I think for me, the key points of this would be: don't do it yourself. You know, anything you're not sure of, refer out. And I'm sure your clients would appreciate you doing that rather than having to go yourself and getting it wrong.
I totally agree with that. I mean, the big problem is that all civil jurisdictions, pretty much, and most Sharia jurisdictions have forced heirship rules. So your will, you know, may be a perfectly valid will in the foreign country, but it would be like somebody trying to deal in a will with property that was passing by survivorship. You know, the will just can't alter those forced heirship rules. And there's no way in which anybody can be an expert in the rules of succession in a whole variety of different countries.
Yeah,
No,
just to add to that, I think what I would say is, if you are struggling to find a lawyer in that jurisdiction, you know, use a resource like the STEP Handbook that will have the list of STEP members all across the world, because you know, that will then show that they've got the relevant expertise to advise.
Good point.
Yeah, no, absolutely. It is something, actually, funnily enough, that we get approached about an awful lot, asking if we can advise on. Estate research are very much not lawyers, as Leslie and James both very much know with myself. But yeah, we get regularly asked, often because about, you know, we do a lot of work around assets internationally. And the vast majority of cases I've come across have had wills covering the assets in the countries where they were. But that's just my layman's opinion from the things we've seen with our international asset service. Okay, next question. I'll address this firstly to you, Professor King, but James, feel free to chip in. Is it possible to decide whether an Inheritance Act claim is likely to succeed? The cases seem confusing and contradictory.
The problem with Inheritance Act claims is that they are incredibly fact specific. So you could have what looks at first sight like the same situation: an estranged daughter, dad dies, leaves estranged daughter nothing. In one case, the daughter might succeed, in another, she wouldn't. But it would be because there were different relevant considerations. So I think the thing to do is always to use a bit of common sense. You can look at the Act, you can see the factors that the court has to take into consideration, and you try and assess the likelihood of success, trying to put yourself in the position of the court. The most important thing to remember is that unless you are a spouse or a civil partner, you are only entitled to reasonable provision for your maintenance. So if you've got an estranged child who is in a position to be able to maintain themselves appropriately, they won't even get off first base. And there are a lot of unsuccessful applications from what you might think of as entitled children, you know, children who have this sense of entitlement. You know, of course I should be inheriting dad's estate. You know, he's got the temerity to want to leave it to his new wife. How outrageous. But another thing that's coming through loud and clear from the courts is the principle of testamentary freedom. So people are free to leave their property as they wish. They are free to be malevolent and spiteful if that's what they want to do. The only limitation that we have on testamentary freedom is the 1975 Act, and the applicant has to be able to demonstrate that they deserve something from the estate. And the court decides whether or not you deserve something by looking at the various factors. And financial need is a necessary requirement for everybody except spouses or civil partners. But as the Supreme Court said in Eilert and Blue Cross, need is a necessary but not sufficient requirement. So You know, if you're a non-spousal civil partner, you've got to be able to demonstrate financial need. Then you've got to be able to demonstrate why the court should interfere with the testamentary wishes of the deceased. So actually, it is really quite hard for a claimant to succeed, but just taking sort of the other view, if you're acting for the beneficiaries, there's an awful lot of nuisance value in claims. And if you think that somebody has got a halfway decent claim, then you probably will come out of it better if you try and reach some sort of compromise with the prospective applicants. But that's where they have a halfway decent claim. In the session that I did and the notes, you know, there are a couple of cases where the courts have commented on applications being made in absolutely hopeless cases, and that should never happen. You know, if you're advising somebody who has a hopeless case, you really don't want to be taking it to court with all the attendant costs. I'm sure you've got things to add, James.
Well, 2 points for me, Leslie. I think the first one would be, you mentioned the case of Islet. My own personal view was that at the time it was very badly reported, and that led to a lot of people wanting to bring claims because, you know, I remember at the time, reported it's opened the floodgates, you know, and I remember having an interview with someone mentioning that. They said, "You don't think we reported it badly, do you?" I said, "No, of course not." They did. So I think that's the one thing. I think since that case, a lot of people think it's easier to bring a claim. But also I've seen in practice, it's just following on to the point you made about the beneficiaries claiming. I think a lot of children, the chance in their arm, and it then does come down to that value judgment of actually how much we were willing to pay to get rid of it. You know, and I know on one case I was involved in last year, the rightful beneficiaries ended up for 50 grand. If it goes away for £50,000, we'll pay it. And they did. Even though we said to them, there isn't a hope that this, you know, that they're going to get anywhere with this, but they decided they didn't want the litigation risk, so they decided to make the offer, and it was unsurprisingly accepted.
But it is so stressful. I mean, litigation is just extraordinary. You know, the amount of distress that it causes. And if you're in a family situation, you know, people are going to take sides, and it's going to cause irreparable damage. So, you know, it sticks in the throat, doesn't it, to be giving somebody something when just to shut them up and please go away. But it often is the best thing to do.
Yeah, and we all know that a letter from a solicitor lights the blue touch paper. Even if it's a very pleasant letter, it will be read wrongly, and the family dynamics will forever be changed. So there's a lot of emotion that gets involved in the Inheritance Act claims as well.
I think that emotion side of it's really important. I used to go to the principal probate registry in High Holborn in London, and one day I went there and there's security. And I was sort of searched extensively, and they took a shaving razor blade. Later that day, I went to see my friend who worked in the Houses of Parliament, and their security was far less than the principal probate division. And part of that was, when I asked the probate division, was because family members turning up and physically fighting over these things, you know. So you're quite right in everything you say about the emotion there, both of you. Right, next live question that's just come in. So I'll throw this open to you both. I'm going to read this, so forgive me for leaning in here. It's in very small writing for my poor eyesight. In IPFDA 1975 claim, does the court take into account property held by the deceased abroad, both jointly or solely, in considering an offer of life interest for the claimant, wife in the matrimonial home? What factors are considered by the court? So do forgive me, I've read that verbatim. I don't know if you can both see that.
Yeah, I can see it. I'm slightly puzzled by the last bit, but perhaps enlightenment will dawn. As far as the first bit's concerned, the court will take into account all of your assets, and it doesn't matter where they're situated, although there are often problems valuing property abroad satisfactorily. But in principle, your worldwide assets are available for the court to make an order. And it doesn't matter whether they are in the deceased's sole name or they're held jointly. It is possible for the court to recover the share of the deceased which has passed by survivorship. There used to be a strict 6-month time limit. If you were outside the 6-month time limit, 6 months from the date of the grant, and you got leave to apply out of time, the court used not to be able to access property that had passed by survivorship. But that was all changed in 2014. So your share of property which has passed by survivorship is available to make a family provision order if the court thinks that it will be helpful to take that property. So that was the first bit. Now, this second bit, in considering an offer of life interest for the wife in the matrimonial home, I'm guessing that means, well, I'm not sure whether it means if the wife has been left a life interest in the deceased's will, is the court going to think that that's enough? So I'll talk about that, and if that's not what the question's about, you can always put something in afterwards. But one of the things that comes out a lot in 1975 Act claims by spouses is that the court is required to consider, this is one of the factors the court has to take into account, has to consider what the spouse would have got had the marriage ended in divorce rather than death. And obviously, since the House of Lords decision in White and White back in, is it 2007? Anyway, quite some years ago now, the marital assets, the court takes the approach, well, why wouldn't we divide up the marital assets equally between the two parties? So you would expect to get, a significant portion of the marital assets as a capital payment on a divorce. So if when the first spouse dies, they had the bulk of the assets, so the surviving spouse has very little capital of their own, and all they've been left is a life interest in a trust, the Court of Appeal has said in several cases, well, that's very different from what they would have got on a divorce. On a divorce, you would get some capital. And the Court of Appeal has commented on the fact that even if you're quite an elderly surviving spouse, it's actually appropriate that you should have some capital that you can then leave to your own beneficiaries of choice. It's not appropriate to simply go, oh, you're 85, all you need is a bit of income to get you through the next few years, that's fine. No, the court will say, well, why wouldn't you have a slab of the marital assets as capital? That's me done.
Anything to add on that, James, at all?
No. No,
oh, absolutely brilliant. Okay, so we'll move on to the next question. James, perhaps I can address this to you first. Yeah. What should we do if we have concerns about a client's capacity?
So that's a really good practical question. So a lot of this, I tend to look at things from what we do on a day-to-day practice level. So that's a great question. So if you are seeing someone about the will and you have concerns about the capacity, so while you're having the meeting, obviously you should be continually assessing the capacity, to see whether you can make that decision in practice. So bearing in mind the Banks and Goodfellows test, the golden rule. So always keep that at the back of your mind, especially the way you are structuring questions, see how you can help them. If you are concerned, and obviously we are not fully trained to assess mental capacity, I think the main thing is you've got to be quite candid about how you do it and be quite gentle in how you steer the clients towards having a formal mental capacity assessment. And that can always be couched in the way that it's in the client's best interest to do so, because everyone wants to know that they're doing the right thing. And if a testator was made aware of the fact that, well, if we're not 100% sure your will could be challenged and your wishes may not be seen, then they may be more amenable to having that mental capacity assessment. I think the next question to consider as part of that would be, well, to whom are you going to make that referral to? And obviously, if someone's considering making a will, we don't want to have an unnecessary delay. And I'm not going to go into delays, negligence in wills, but you need to consider whether that's to go to the doctor, to the GP. The question would be whether they are qualified enough to do that, whether it's to go to a consultant at the hospital. I think the considerations there would be, well, how long is that going to take to get the referral through? Or you look at something like an independent mental capacity assessor. From practical experience, they've usually been quite good in being responsive. Yes, there is a cost to that, but they are able to specifically cover the question, and they are qualified enough to say, is this person able to make a will or not? Or, if you're stretched out to lasting powers of attorney, are they able to make the lasting power of attorney? Can they make that decision in question? So I think the most important thing is how you handle it. It's really kid gloves, handle it carefully, but it's really important. We're seeing an increase in claims against estates, just to make sure it's done correctly. So those would be my points. I really look at things from a practical basis. Leslie, would you have anything to add on that?
Totally agree with you that if you do have doubts, you want to suggest to the client that they consider having an assessment. And I just imagine myself what my reaction would be if someone said that to me. So tactfully and sensitively certainly are the words that spring to mind. Yeah. I've had loads of people saying to me that GPs are increasingly unwilling to do it, and you can entirely understand why. It's not their job, it really isn't. And also the quality of their report is unlikely to be particularly good or particularly persuasive. So I would always say, if you can possibly afford it, use one of the independent capacity assessment organisations that's out there. There are lots of them, and I've had several people giving me glowing reports of how prompt they were, how good their reports were, how helpful they were. And I'd just add one other thing, which is you may very well have a client where you have no doubt at all about their capacity, a really sharp, sparky 85-year-old, but they're doing a will which is cutting out one of their children. You just know that that disinherited child is going to be turning over every stone to, attack that will. And so even where you don't have doubts about capacity, it's very, very often appropriate to suggest getting a capacity report. And even if you don't do that, just go the extra mile in your attendance notes and what you write, and, put in as much evidence as you can as to why you thought that person had capacity.
I would agree. It's a while ago, a couple of years ago, when I was practicing, and had a case like that. The client was great. She was late 70s. She was disinheriting her son, and to the very extent, and there's perfectly valid reasons why. So we recorded it in the attendance notes. It had nothing to do with her. It didn't have anything to do with the family, and the daughters looked after her since her husband died. Did everything for her, and she decided she did. If he didn't want to have anything to do with her, then fair enough. He wouldn't benefit from the estate. So once we explained, actually, there is a we went through there is a chance you could bring a claim against your estate. So to protect against that, you should get a mental capacity assessment, even though we know, it was the belt braces battening down the hatches just to protect her. And as soon as we explained that to her, she was fine. Yeah, no problem at all. And she understood that a will wasn't a cheap commodity, which unfortunately most of the market seem to believe that they are, and that she understood the value of our advice, and then understood the value of actually making sure that her wishes, i.e. the daughters, were to inherit everything. It was ship shape and Bristol fashion, and she knew that the capacity assessment was enable her to do that, and ultimately she got the peace of mind.
Yep.
I'm smiling because I had a case last week where a testator had 3 children, one of whom he did not appear to get on with. and disinherited the youngest child and left a small note in the will saying he is to receive 1 pair of my old socks. And it just tickled me, really. But that's by the by. Right, we'll move on to a live question that we've just had in, which I'll throw open to you both. If the resident nil rate band is available in an estate, do the descendants have to take it as a part interest in the property, or can they take an equivalent value from other assets? So it's a really interesting question.
If you're talking about a residence which is in the estate, then you will only get the residence nil rate band if lineal descendants inherit part of that residence. So you have got to. You don't have to keep it, but it has to be left to you in the will or under the intestacy rules, or you have to take it by survivorship, but you have to take an interest in a residence. You can direct the PRs to sell it, but you have got to inherit it. So you have got to take an interest. If there isn't a residence in the estate, or if the residence is too cheap to get the full residence nil rate band, then it may be possible to get a downsizing allowance, provided lineal descendants are inheriting other assets. But if we're talking about the residence nil rate band proper, you have got to take part of the residence.
Excellent. Yeah. Anything to add on that, James, or should I move on to the next question?
No, nothing to add there. No.
Excellent. Okay. Next live question that's come through. Re-solicitors drafting wills for their parents. The Law Society guidance states that this is acceptable where the terms provide all to the survivor and then on to the children. However, where one of the parents has an estranged child whom they are not providing for, is this opening up a potential argument for undue influence? Should the parents document their wishes separately, or should the wills be redrafted by another solicitor? Another really interesting question that I'll throw open to you both.
I don't think you should. Yeah, I think I'm very cautious as an individual. So with anything, I know there's the guidance. On a personal basis, I would, you wouldn't want to be involved with it. It just really opens a can of worms.
Yeah, I totally agree. I did do my mother's will. I've got one brother who doesn't have any children, and I've got one daughter. And I remember my mother saying to me, well, how much do you think I should leave your daughter? At which point I thought, this is not a very good scenario here.
Everything, absolutely everything.
So I did decline to continue.
I was asked by my own parents recently to recommend a solicitor because it turns out my parents had been slightly ripped off by a dodgy will writer many years ago, and I was appalled to find out they were going to be intestate. I think I've told James this story before, actually. And my parents asked me even to recommend someone, knowing that I work with wills and probate lawyers around the country. I was even reticent to recommend somebody. Because I was worried about that, because I think there will be an issue of potentially disinheriting and stuff. And I didn't even want to be involved at that stage. So I think I think caution definitely is your friend on this one, isn't it, really? We'll move on to the next question. I'll direct it to you first, Leslie. In relation to Inheritance Act claims, how does a standstill agreement work?
You probably don't really need to know this unless you are a contentious practitioner, because it is all about the nitty-gritty of actually bringing a 1975 Act claim to court. But the problem is that there is this time limit that unless you get your claim out within 6 months after the date of the grant, you have to get leave of the court to issue your claim out of time. And a practice has grown up that where people are negotiating, so, they're discussing the merits of the claim, and you're coming up to that 6-month period, neither side really wants to issue the proceedings because they're hopeful that they can actually get it settled. And so what tended to happen was that the parties would agree between themselves well, if we can't reach a settlement and you do have to make an application for leave to apply out of time, we won't oppose it. We will say that we are happy for this claim to be given, to go ahead. And in a case called Cowan and Foreman, Mr. Justice Mostyn had a complete meltdown over this and said this was a totally appalling way of proceeding. And it was only the court who had the power to decide whether or not to allow leave to apply out of time. And it was outrageous that the parties were ousting the position of the court, usurping it. So he went on at quite some length about it. But when we got to the Court of Appeal, which we did very, very quickly, the Court of Appeal pretty much disagreed with everything that Mr. Justice Mostyn had said, and they disagreed over the standstill agreements. And they said, of course it is for the court to decide whether or not to allow an application out of time. But they said, it's in everybody's interests that agreements should be reached, if at all possible. And issuing proceedings often just hardens everybody's approach. So they said, two of the judges in the Court of Appeal addressed this issue, and they said they thought it was very unlikely that if the parties had agreed between themselves that they would attempt to achieve a settlement and there would be no objection to an out-of-time application if they failed, they thought it would be very rare for the court to take a different view. But one of the judges in the Court of Appeal did add a sort of caveat to that, which was, if you are reaching such an agreement, it's very important that it should be in writing and all the details should be set out. So it's just a way of buying some extra time for negotiation. You want to add anything, James?
No.
No, lovely. A big shout out to your cat who made a guest appearance just behind you there, Leslie.
It's not actually my cat, it's my friend's cat.
Absolute star of the show today, I'm afraid. It's taken all the shine off the three of us now, I'm afraid to say. Next live question for you both. If a gift has already been made and a client comes in to discuss a deed of variation, can it record a gift that has already been made? A client has been suggested it may do, but this was not our understanding of the rules. It would seem to be trying to rewrite history.
I don't know what it means by gift. If it means lifetime gift, then all that the donee could do is give the gift away themselves. There is no procedure for rewriting a lifetime gift. If it's referring to a gift by will, which I doubt, then of course it is possible to rewrite the will for the purposes of IHT and capital gains tax, but not for other purposes. So for IHT and capital gains tax, the deceased would be treated as having made that gift. But with lifetime gifts, no, there's nothing you can do.
Yeah, no, I agree. That's why I'm pulling a puzzle face.
Yes.
If it's been gifted in lifetime, it's gone, it's done.
You can give it away, but you will be making another gift.
I suppose, unless it's meaning, the gift's been made in lifetime and the family are now trying to do a deed of variation to take that gift into account by using a deed of variation. They want to include it in the recitals, but why would you do that?
One thing has just occurred to me. I guess you could disclaim the gift if you haven't had any benefit from it, but I doubt that's what it's getting at. I think we're both a bit puzzled by that one.
I very much enjoyed the puzzled expressions on both of your faces. Just staggeringly similar there, I have to say. Okay, so we'll move on to the next question. Perhaps it might be a good one for you, James, since you mentioned that you're the guy for practical advice. Do you have any practical suggestions to mitigate risks when preparing a will? Really good question.
Yeah. Okay, I think there's a few practical suggestions here. The first thing is, and I say this slightly tongue-in-cheek, I think you need to make sure that you are charging appropriately for the advice that you're giving and not chasing the market to the bottom, because there's no winners there. But on a serious note, I think you ensure that it's the appropriate person to take the meeting. And I've had that, when I first qualified. I was a newly qualified lawyer. A meeting got put in my diary. I went to see this person. Turns out she was going to inherit £30 million. And she got a 6-month qualified solicitor who had no idea. I think I actually said, well, how do you know you're going to inherit? You might get disinherited. Something that I wouldn't say all these years later. And I only got put in my diary because the partner of the department was on holiday. And when he came back in, he was aghast that I'd actually been able to see this client and try and take some will instructions, which in hindsight was far beyond my capabilities at the time. When it relates that to mental capacity and talk about it, I think, again, it's important to ensure that the appropriate person is there who can assess that capacity, and that really does come from experience and being able to identify and ask the difficult questions. There's a great skill in asking the questions that the clients don't want to be asked. And it's only through years of experience where you're speaking to a client, you go, there's something not right here. I had one client about 10 years ago, and I remember saying, there's something not right. What aren't you telling me? And it turned out the reason why they come to make a will is that the husband had fathered a child on a stag do. And they got to knock at the door 6 weeks before they came to see me with a surprise, here's a baby. But it's that skill in asking the difficult questions. So it's the appropriate person taking the meeting. I think that in all cases, as far as possible, you should see the clients alone. This really does take away the risk. For those of you who maybe have glass meeting rooms, if you keep the children outside and keep them in the reception, it's amazing how small the bladders are as they keep on walking past the window trying to see what mum and dad are doing. So always sit, make sure you're facing the glass partition and not the clients. Again, you keep in mind undue influence. Record everything. Detailed attendance notes. Your attendance note is your shield. For those of you who have ever seen any of my talks, I'm a great advocate of a good attendance note. I love an attendance note. Also, other mitigation factors is time delay. Keep the time delay to a minimum. I think it's the case of White and Jones, one of the big negligence cases about wills. But ask the question: are you going on holiday soon? Any illnesses? Older clients, don't let it sit on your desk. You need to get the drafts out and encourage the signing of the wills. Also, the final part is the signing meeting. And it's amazing how many wills, in my previous life, used to come across my desk that have been witnessed maybe by a secretary and an admin assistant. When it comes to mental capacity, you need, aside from mental capacity to have a retainer with you, it's you need mental capacity at the time you sign your will for that will to be valid. And I think it's very irresponsible to treat the signing meeting as a mere formality. If possible, you should have the same person who took the instructions, who's dealt with the clients all the way through the process, to take that meeting, because they are able to see whether there's any changes, anything like that, and are able to ask the questions, go through the will, with them, ensure they understand it. And again, of that meeting, take full notes. And this is why it comes back to my initial comment that was slight tongue-in-cheek about making sure you charge appropriate. If you are doing say a pilot high, sell it cheap wills service, you're not going to be able to offer that level of service for that price point. So this is where really I think it's educating clients that the will is just the output, it's the tangible product of the intangible advice, and it's the intangible advice and the whole process and that family protection in what your client's paying for. I just think as a profession we're really bad at explaining that. And here endeth today's sermon. So
I'm going to add two things. I'm going to add one, which is ask them if they've made an earlier will and then see it, because if there's a big difference between the two, that immediately gives you questions to ask.
Yeah.
And then the other thing, I was just thinking, I totally agree, treat the execution as really important. There's a case called Coles and Reynolds where I was terrifically impressed by what the firm had done. So it was a case where they could clearly identify that there was going to be a problem when the woman died, because she was disinheriting one daughter and leaving everything to the other. And it may be because of that that they really pushed the boat out, but they did a most excellent job. And I was quite taken by the fact that they had standard checklists, questionnaires, which were sort of pre-populated down the side with, you know, how did the client appear? Was there anything that raised an issue about mental capacity? And then they filled in opposite with their own notes. So that was quite helpful. And there was a really detailed one about the taking instructions interview. Then there was an equally detailed one on the signing process. And they were actually seen by a different fee earner, which is why I was kind of looking, and actually that different fee earner took the testatrix through the will, checked the reasons for making the will, checked the reasons for why it was different from the previous one, and then made her own notes. And so I totally see your point about, you know, you can see any differences, but of course there's also something to be said for two separate people seeing and recording their views. But I did really think that the two lots of you know, notes were excellent.
That's a really interesting point, Lizzie. It's just reminded me of a case I came across in practice where they'd actually the video recorded the signing of the will because they had concerns about capacity. The problem was, and this is the overarching, unfortunately, the will wasn't great. So it was brilliant that they'd actually recorded everything, but the tangible product wasn't great. And it was something that is actually when we did our last session together. You know, one of the things that I used to do was always, when a will was completed, do a Larkin-Nugas questionnaire on the file as part of file closing. And if you remember, we had a couple of minutes talking about it. I think that's something that can be really important as well, because in most cases, the fee earner will have left the firm by the time that will is challenged. So by having that Larkin-Nugas questionnaire on file at that stage, it's fresh. It offers a lot more protection to the firm than trying to chase down a fee earner who may or may not want to help you.
May not remember.
May not remember, or may no longer be with us. There's a few cases I've come across. So I think it's really important to ensure that everything's accurately recorded. But the checklist idea you just mentioned there, I think that's something that, you know, should be considered by people. I think that's a great thing.
Yeah.
I was staggered last week. It's slightly off topic, but I was staggered last week to see a will in which the major residuary beneficiary was also the witness. And you'll be unsurprised to hear that we were then asked to find the intestate beneficiaries. But absolutely flabbergasted. So yeah, I think everything you said there is spot on. I think we've got time for one or two more questions before we finish. So I'll address this one to you, Leslie, first off. Regarding my favourite topic of the year, the TRS, if you register the estate as complex, do you still have to register a trust created in the will?
Oh, yes, yes. Register everything in sight, frankly. It's a completely separate thing. So you have to register an estate if it is complex, which is basically if it fulfills any one of three conditions which the revenue set out. And it's basically size of assets, amount of income and capital gains during the administration period, and the value of assets sold in a particular tax year. So if your estate fulfills any one of those requirements, then the personal representatives have to submit a tax return for each tax year of the administration period, dealing with income and gains. If it's a simple estate, they don't have to do a tax return. They simply wait till the end and then do one big calculation. Now, the problem if you have to put in a tax return is you have to tell the revenue that you need a tax return. And the only way now of telling the revenue that you need a tax return is to register details of the estate on the trust's register. It's very brief details. It's just details of the deceased and the personal representatives. So you do that if your estate is complex. And then quite separately from that, your will may create trusts. And if your will creates a trust, which is in existence more than 2 years after the date of death, which will happen quite often because, estates often take quite a long time to administer. So if your trust is still in existence, then it has to be registered. And it isn't just the obvious. So, I mean, you'd look at a will and it might have a life interest in it, or it might have a discretionary trust in it. And so you think, yeah, we've got a will trust. We'll have to register it after 2 years. But the revenue, rather annoyingly, take the view that if you have what they call an administration trust, which is where your estate is left on trust to my trustees stroke personal representatives to pay the debts, legacies, and then hold the balance for X. Revenue takes the view that's a trust. And so if your estate hasn't been completely administered and you haven't paid over the assets to the residuary beneficiary after 2 years, you will have to register that trust. So, as I said, it's not just limited to obvious will trusts. So annoying. The whole thing is so annoying.
I've enjoyed the TRS. It's given us a lot to talk about all year. If nothing else, it's kept everyone busy. And I'm sure most practitioners don't feel the same way. James, you've nothing to add on there just before I move on?
Apart from TRS being extremely annoying.
That's going to be the takeaway of the session today, isn't it, for the delegates? Okay, I think this next live question that's come in, and we've probably only got about 4 minutes for this, but I'll put it to you both. I think it loops back to the question before last. Someone's gone on to ask, can we have some clarity on what the Lark and Nugas checklist includes? Is there anywhere they can turn for that, or any comments you have?
Yeah, more than happy to do that. So, Lark and Nugas checklist. To be fair, there's no such thing as an official Lark and Nugas checklist. It's something that I, being quite a risk-averse individual, brought into use at previous firms of my own. It's based upon the case of Lark and Nugas, which basically says, this is a very high-level overview, that it's not for fishing exercises, but if there is an issue with the will, there's potential of litigation, then there are certain questions that the claimant solicitors can ask about the will preparation and how it came to pass. So in that case, there's various questions that it was deemed that it could be raised, and it's about how the will was signed and the process that they went through. I'm not going to say that I can remember all the various questions. However, what I can tell you is that there is an extremely useful practice note prepared by the Law Society, which is on the Law Society website. So what you may wish to do is log on to your Law Society account, search in the practice notes under private client for Lark and Nugas, and in there's a very helpful bullet point list of the various questions that can be asked. And all I've done in the past is looked at those questions and then made sure that those are covered in a checklist. Questions on the left, answers on the right, and make sure that they are filled in as as part of the file closing checklist. So the best advice I can give is have a look at the Law Society website and then decide for your own firm what risk mitigation it may be. You may look at it and think, okay, that's a bit over the top, but look at it from your own risk profile and what you want to achieve and decide what you want to put in there.
I think, well, I know that ACTAPS, the Association of Contentious Trust and Probate Specialists, has a standard Lark and Nugas letter, which I think, well, it's on their website and I think it's generally available. So, I mean, that's another possible source. I think about if you've ever been on the receiving end of a Lark and Nugas letter, inquiring, I mean, some of them are absolutely outrageous. I mean, they go on for kind of 50 questions, and so having something which you can say, look, we completed this at the end. Nobody has got a better recollection now than they had at the time. Yeah. Here you are, mate.
And I think in practice as well, is that feeling that you get when if one comes in, and I'm not going to say we've had a lot, but if you've got the answer, it's that peace of mind knowing that it's covered, and rather than 10 years down the line going, crikey, I don't even remember that client. So it's just that peace of mind for you.
And I'll just say one other thing. You know, you were talking about your fee earner might be dead. Your fee earner might be demented. Because one of those big RSPCA cases, that was one of the problems. The person who'd taken the instructions, you know, no longer had capacity themselves.
Yeah.
Okay. Well, I think unfortunately, I can't believe that's gone as quickly as it's gone, really. Absolutely. Really interesting questions.
When you're having fun.
I know, there you go. No, really, really interesting from you both. I'm ever so grateful to you both. I thought that was absolutely excellent. It is all we've got time for, I think, today. Just a thank you to you both, to James, to Leslie. I'm sure on behalf of all the delegates, we've had lots of nice comments I've seen on the chat there. People saying thank you for the answers and things like that. So thanks from me to you both again. Thanks for all the delegates for attending the Law 2022 Online, Wills and Probate Shape the Debate. Don't forget to join the Solicitors Group Law 2020 Online community on LinkedIn. Estate Research, I'll cheekily add her on LinkedIn as well if you want to give us a little bit of a follow on there. Just advertise myself there. But do give Solicitors Group a follow on LinkedIn to continue the debate after the session. If you've purchased the online course, there's still time to watch the pre-recorded content, and your expiry date will be displayed next to the webinar. All of those of you who have not, there's still time to buy the complete event, including a recording of this very live session. You just go to www.thesolicitorsgroup.co.uk. That's www.thesolicitorsgroup.co.uk, where you'll also find the online exhibition. The exhibition is open for anyone to visit, and if you've booked the entire package, you can claim your 1 hour free CPD webinar from the webinar learning catalogue, which I'm told is worth £35 plus that. And after viewing the online course, the Solicitors Group would be tremendously grateful if you would complete the feedback form that is available in the related links section, and then you will receive your CPD certificate via email. Just finally from me, big thank you to everyone who's attended all of the Solicitor Group events this year, everyone that's come up to the stand at Estate Research and met us all. Really grateful for you all for all your time this year and for your time today. James and Professor King, thank you so much from myself again for all the live events that I've been at with you both this year and for your time today. I really did find that was a really, really entertaining session. I'm sure you can both see all the thank yous that are coming through on the chat there as well. And to everyone, stay safe and well, and we'll hope to see you again really soon. Goodbye and have a nice afternoon.
Thank you, Dom. Bye. Bye, James.
Bye.
Goodbye, everybody.
Bye.